This calls Taylor Hopson to the stand. Good morning, Ms. Hopson. Would you please introduce yourself?
My name is Taylor Hopson.
Do you know why you're here today?
My best friend was killed.
And is your best friend Mrs. Sullivan? How did you two become best friends?
I moved in next to her when I was 8 years old, and we just found out everything we had in common, and we were inseparable from then. We had walkie-talkies, so that when we couldn't go outside and play, we could still talk, and when we did go outside, we'd play princess, and in middle school, we would decide which boys were cute and who wasn't, and we bought our prom dresses together, walked down the aisle of graduation together. How could you not be best friends with someone like that?
Ms. Hopson, I'm going to ask you a few questions about the night of the accident. What happened first that night?
Vanessa came to get me around 6:45, and we were at Chuggy's at around 7.
Was there anyone else you were meeting?
Yes, a friend of hers from college, Danny Dawson.
The defendant.
Yes.
And did you two plan on drinking that night?
Yes, it's her 21st birthday.
How are y'all going to get home?
Vanessa told me that Danny said he would be the designated driver.
Whenever y'all got to the bar, what happened?
Well, as soon as we walked in, I saw Danny, and so I went to ask him if he would be the designated driver so me and Vanessa could drink. And he told me to lighten up. He said anyone could have a drink or two and still be fine to drive. I was kind of confused, but he told me that he probably wouldn't be drinking anymore that night.
Ms. Hopson, did he drink more that night?
Yes.
After you spoke with the defendant, what happened?
We moved to get a table so we could see the band better.
When y'all sat down, did anyone have anything to drink then?
As soon as we sat down, he ordered straight whiskey. And he didn't stop there. He got a beer and a shot as well.
What happened next?
Well, we all started talking, and he went to the bar. I was really happy about that because I got a chance to catch up with Vanessa. I don't ever get to see her. She barely comes back home.
You went to the bar, and then what happened?
Well, he went to the bar, and then when he came back, the band was about to start performing.
And then what happened after the band performed?
Well, immediately after the band performed, I went to the restroom after their first set. Our waiter, Pat, he was refilling the drink so fast, I had to switch to tea, and so I had to go to the restroom. And when I got back, I saw Danny on the stage with the band's guitar.
Objection, relevance.
Your Honor, how the defendant was acting, especially in a bar setting, doing something like playing a guitar is extremely relevant, and it shows just how he was acting before the night of the incident.
It does not show any relevance to how the crime happened. And
so you said he was on stage playing the guitar?
Yes, it was embarrassing. He had to be dragged down off the stage by a bouncer. It was all Vanessa could do to get them not to kick him out.
Describe his demeanor while this took place.
He looked like he was messed up. He was stumbling, not in the right state of mind.
After he was, you say, dragged off the stage, what happened?
We decided to leave.
And how was the defendant acting now?
Like I said, still the same way. I'd gone on stage before then to sing Vanessa's favorite song with the band. We knew the band. And I sang Sunday Morning. It's her favorite song. And then we decided to leave, and he stumbled out to the parking lot. And when he reached over to open the door, his breath reeked of stale beer and alcohol.
Did the defendant end up driving?
Yes.
I have to ask you, I'm sure the jury's wondering, why did you ride with the defendant if he was stumbling and smelled?
It was a mistake. If I knew that that was going to happen to Vanessa, if I knew what I knew now, I wouldn't have gotten in the car, but I wasn't thinking, and by the time I realized how bad he was, it was too late, and he was going really fast, and he wouldn't stop the car. I couldn't get out.
How was his driving?
It was terrifying. He was speeding. I felt like he was going 80 miles per hour, and he was swerving, and we kept begging him to slow down, and he wouldn't slow down.
Did either of you ask him to slow down?
Yes, both of us, me and Vanessa. Vanessa even called her dad to let him know we'd be a little bit late, so that Danny would drive slower.
Did the defendant say why he was driving so fast?
Well, he kept us out a lot later than we planned to be, and Vanessa, she has a curfew, and we were saying we weren't going to make it back in time because Danny kept us out so late, and he just laughed and said he could make it in 8 minutes. And I live right next to Vanessa. It's a 20-minute drive, and he took it as a personal challenge that he would do it in 8.
You said that Vanessa called her father. Did he pick up? So, did Vanessa leave a message?
Yes.
Have you heard that message since the original time?
Yes.
And do you think that you would be able to recognize it if you heard it?
Yes.
Objection leading. Your Honor, I'd like to play the voicemail recording that we spoke of earlier. Hopson. Pass the
Mr. Hopson.
Ms. Hopson, this is going to be hard, so if you ever need a minute, just tell me and we'll take a bit for you to recompose again. Now, you don't normally drink. Would you say that you normally drink?
If I'm going to a bar,
But you don't regularly drink?
I'm not an alcoholic. I don't drink every single day. If that's what you're asking.
I'm asking if you regularly drink.
Regularly, like every day?
No. Now, you didn't know your limits.
My limits?
You did not know your limits. You don't know your limits.
My limits to what?
Your alcoholic limits.
I can't calculate it down to every single drink, every drop of alcohol. If that's what you're asking.
When you used to work at Chucky's, the customers often complained that Jordan James, who was the bartender that night, poured the drinks too weak.
Yeah, I've heard that, but I had his drinks.
Objection, hearsay that all of the customers are not here today, and they're making statements for the truth of the matter certain.
This isn't for the statements of the customers, this is for her presence and suppression.
May I respond? His words were the customers said that he is using the customer's words, and it is to infer that the drinks are strong or weak.
Stand up, sorry. Now, Canyon Road is called the death zone in Midland.
Objection. This is more prejudicial than probative.
This is to show that the road is known to be dangerous by common knowledge and could have caused the accident outside of their recklessness.
If that's what he's trying to elicit, then I have no problem him asking whether or not the road is dangerous. I have a problem with him using the words death zone.
The death zone is what Midlands and the commoners, it's common knowledge is that Canyon Road is called the death zone, and it will be testified to.
I'm not allowed, I think your objection goes to wait
Now, Canyon Road is called the death zone in Midlands, correct?
Yeah, some people sound like that.
You've actually had friends who died on Canyon Road in the death zone.
Some high schoolers have died there before.
Now, Canyon Road has a number of curves, correct?
There's this one particular curve.
Okay. And there's a lot of trees in that area.
Yeah, there's trees.
And where the accident happened, there is no guardrail.
No.
And that night, there were no lights on the road except for the headlights and the light from Linda Benton's house.
That's correct.
And it was raining torrentially.
Yes.
And you didn't see anything in the road.
Oh.
No further questions.
Nothing.
Thank you, Ms. Hopson.
Yes, Your Honor, the prosecution calls Officer Foster to the stand. Good morning, Officer Foster. Can you introduce yourself?
Certainly. My name is Officer Ryan Foster.
Officer Foster, how are you involved in this case?
Well, I'm involved in this case in two ways. I was the first responder on the scene of the crime when it actually happened, and then after that night, I did what we call an accident scene reconstruction, determined exactly what happened.
First, let's talk about the scene of the crime. Why were you the one to respond?
Well, I was on patrol duty on Canyon Road that night. I was the closest patrol cop to the accident, so I'm the one they called to go to the scene.
And what happened when you got to the scene of the crime?
The first thing that I noticed was a white Chevrolet Impala had run off the west side of the roadway. It seemed to have struck a tree. The next thing I saw was a young man pacing around in the roadway.
What did you do when you first got there?
Well, of course, the first thing I do is what we call controlling the scene. see if anybody needs immediate medical attention, put up some flares in the roadway to prevent any further accidents, make sure none of the evidence gets contaminated.
Was there anyone that needed immediate medical attention?
Yes, there was a young woman in the passenger seat of the vehicle that I later identified to be Vanessa Sullivan. She was not breathing and she was not responding at all.
What did you do after you got medical attention for Vanessa Sullivan?
After the scene was secure and the EMTs had arrived to take care of the young woman, I began to interview the defendant.
Well, what happened when you interviewed the defendant?
Nothing very helpful. He told me that he was sorry for not keeping better control of the vehicle. Then he told me that he needed another drink.
The defendant told you that he needed another drink?
Yes, he did.
Did the defendant ever mention swerving because he saw a deer?
No, he never said anything like that. Not a deer, not a dog, not any other kind of thing.
When the defendant told you that he needed another drink, what did you do?
Well, I suspected that he was intoxicated. I noticed that he was stumbling a little bit and he was slurring his words. Decided to run a couple field sobriety tests.
What happened when you ran the field sobriety test?
The defendant failed all 4 of the tests that I gave him. Led me to believe that he was intoxicated.
What did you do when you realized that the defendant who had been driving the vehicle was intoxicated?
I placed him under arrest. I took him back to the police station to do what we call a breathalyzer analysis, get an actual scientific reading. Dropped him off at the station and I was on my way.
You mentioned that in addition to responding to the crime scene, you did an accident reconstruction.
That's right.
What qualifies you to reconstruct accidents?
Well, I hold a bachelor's degree in mechanical engineering from the Georgia Institute of Technology. I'm a certified professional engineer here in the state of Midlands, and I worked for the Fatal Crash team for 7 years now.
What type of facts and data do you need and did you use in this case?
Well, of course, the first thing I use is the conditions of the actual scene of the crime. Any skid marks on the ground, rutting in the grass, damage to obstacles. Of course, I take measurements on the actual damage that was done to the vehicle, the injuries that the passenger sustained.
What types of principles and methods do accident reconstructionists use to examine those facts and data?
Well, it's basically the principles of physics. We use the methods of mechanical motion and the way that forces act on free bodies moving in space. We're able to do several useful things, such as determine exactly what happened when the car was sliding out of control. We can also determine the speed that the vehicle was traveling at the time that it lost control.
Were you able to make those determinations reliably in this case?
Yes.
Officer Foster, when you reconstructed the accident, what was the first thing that you did?
First thing I always do is draw a diagram.
Your Honor, may I approach the witness? I'm showing opposing counsel, prosecution's 11. Your Honor, would you like a copy?
Sure.
Officer Foster, can you tell me what you have right there?
Yes, this is the diagram that I made in this case.
And is that a fair and accurate depiction of the crime scene?
Yes, it is.
Your Honor, I offer prosecution's 11 into evidence.
An objection to State's 11.
There, Your Honor, no objections.
Your Honor, is it alright if I show an enlarged copy of that same exhibit? And is it alright if the witness gets off the stand to use this demonstrative?
Yes, I was asking this down.
Officer Foster, I'll switch with you. I have a card here for you. Can you show us what happened when the defendant was driving on Canyon Road that night?
Absolutely. The defendant was traveling northbound on Canyon Road when he approached the specific curb where the accident actually happened. What is clear from the rutting in the grass is that the defendant failed to negotiate the curb properly. What that means is that he didn't turn in time and he wasn't able to stay entirely on the roadway. The right wheels of the vehicle, as we can tell from this rutting in the grass, left the road and he attempted to recorrect himself back onto the roadway.
What happened when the defendant tried to recorrect onto the roadway?
Well, due to excessive speed for the roadway conditions, the defendants pulled himself onto the road, but the wheels were turned too hard and he was just going way too fast. Calls what we call a hydroplane.
He was going way too fast. How fast was the defendant driving around that curve?
Going about 66 miles an hour.
Is that the speed limit?
Speed limit there is 35, considering that it was pouring down rain. Of course, traffic safety would indicate you should be going even lower than the limit, though.
All right, so as the defendant was going 66 miles an hour
That's right.
and slid off the road, what happened?
Well, the tires lost all traction on the roadway underneath them. You probably felt this before if you've ever hit an icy patch on the roadway. Wheel just stops behaving the way you want it to, brakes don't seem to work, gas isn't doing anything. Tires started sliding and the vehicle rotated 90 degrees through the roadway. Went through his lane of traffic, the oncoming lane of traffic, the front end of the vehicle connected with a utility pole off the side of the road. The car rotated counterclockwise and the passenger side of the vehicle struck a tree.
What happened when the vehicle struck the tree?
That was what most likely killed the passenger on impact. She was dead when I arrived on the scene.
Which passenger?
Vanessa Sullivan.
Officer Foster, you can take your seat.
Apparently.
Did that conclude your involvement with this crime?
No. My department also subpoenaed the receipts of the defendant from the night that he had been at the sports bar Chuggy's.
Why do you subpoena receipts?
Well, we want to see what alcohol purchases the defendant had made that night, since we suspected him of driving under the influence of alcohol.
Your Honor, may I approach the witness with prosecutions 2A and 2B? Showing opposing counsel, prosecutions 2A and 2B. Your Honor, would you like a copy?
Sure.
Officer Foster, can you tell us what prosecutions 2A and 2B are?
Yes, these are the receipts of the defendant from the night of September 24th and the early morning of September 25th, the night that the accident occurred.
How do you know these are the defendant's receipts?
His signature is at the bottom.
Your Honor, I offer prosecutions 2A and 2B into evidence.
Any objection from the defense?
No, Your Honor.
2A, 2B are
Officer Foster, how many drinks did the defendant purchase the night of the accident?
17, not including any complimentary drinks he might have received.
I pass the witness. Your Honor, may I publish 2A and 2B to the jury? Your Honor, would you like me to remove the demonstrative?
Mr. Foster, in your direct, you stated that the car was going around 66 miles per hour.
That's right. When it approached the curb, I was able to back calculate that that's how fast he went as he took the curve.
And your gun was calibrated that night, right? Your radar gun was calibrated.
Yes, it was. I didn't use a radar gun to take the reading at the time of the curve. I did get an earlier reading, though.
And when was that earlier reading?
It was, I'm going to say, about 15 minutes earlier that night. The defendant drove past me much earlier before the accident happened.
You've prepared an affidavit for today's case, haven't you?
I have.
And you were under an oath while you wrote that affidavit.
I certainly was.
You under the same oath today.
That's right.
May I approach the opposing counsel or the bench? Now showing our opposing counsel.
What lines are you referring to?
Lines 31 through 32.
All right.
Through 33, I'm sorry, through 33.
Your Honor, at this time, I would like to object to an improper impeachment. The witness has said nothing to contradict his affidavit, and if opposing counsel believes he did contradict his affidavit, he was not given the chance to recant what he said. Therefore, this is an improper impeachment.
Under what rule are you lodging this objection?
Your Honor, under the hearsay rule, it is only admissible a witness's prior statement if it is inconsistent and the witness is allowed an opportunity to afford or deny the statements made against him.
Does that know if this is hearsay?
Yes, because it is an improper impeachment, so it's not a prior statement by witness that's in contradiction, because there has been no contradiction. So yes, Your Honor, hearsay.
Response?
May I ask the specific rule she's talking about?
Your Honor, I'm talking about Rule 801D1.
Your Honor, as it reads in the witness's affidavit, it is a direct contradiction of what he has just said was direct.
I don't know what it says because nobody's told me yet. So I guess I think, first of all, that your objection is premature. Second of all, I don't think he's offering this for hearsay purpose. He's offering it for an impeachment purpose, which, in my understanding, is wholly separate things. So I'm going to overrule the objection. The jury can give it whatever way they want to.
Yes, Your Honor.
This is your affidavit, correct? With your name on the front and your signature on the back?
Yes, it is.
Okay. I'd like you to read alongside with me as I read aloud lines 31 through 33.
Sure.
Where it says, I saw a newer model Chevy Impala coming from the city, approaching the fork in the road. And I got a radar reading of 54 miles an hour. My radar gun was calibrated before I went on duty that night. I have never had any problems getting an accurate reading.
Your Honor, at this time, now I would object to hearsay because there has been no inconsistent statement, so this is not an exception to hearsay, and he was offering this for the truth of the matter asserted.
How so?
He was offering it to show that the reading was 54 miles an hour and that the radar gun was calibrated, things that Officer Foster never disputed, and so it's not admissible as not being hearsay under 801.
Your Honor, in his direct, he stated that he said the car was going around 66 miles per hour, and in his affidavit it said he clocked them doing 54.
Okay, so for what purpose are you offering this testimony?
Offering that there's inconsistency with what he's telling us now and the excessive speed of how the car was going.
How is that hearsay?
Your Honor, it's hearsay because what the witness said on direct is that he back calculated the speed to be 66 miles an hour, not that he got a radar reading on his gun of 54 miles an hour. We're talking about two separate instances. He has not said anything inconsistent. One was a calculation, one was a radar gun reading. They happened 15 minutes apart on different parts of the road.
Okay, I understand that. I'm asking you, why is this hearsay? Because my understanding is this is being offered to show that your witness might be lying.
Yes, Your Honor, I understand that. However, the statements are also being offered to show that the defendant was traveling at 54 miles an hour, and that's the part that's being offered for the truth of the matter asserted.
Are you offering this testimony to prove that the defendant was going 55 miles per hour?
I'm offering that the witness is lying under oath and saying that.
Overall.
So as previously stated, you said that the car was going 66 miles per hour.
That's exactly right.
And then in your affidavit it says that the car was going 54 miles an hour and your gun was calibrated accurately.
No, that's not true. I'm so sorry. I'm not being very clear. When I took my radar reading, that was when the defendant was already driving past me at that time. It was a completely separate time when I did my accident reconstruction later on, and that's what I was talking about, those physics formulas. That was when I calculated that his speed was 66 miles an hour at the time he approached my curb. I'm so sorry if I was being unclear.
No further questions, Your Honor.
You're correct.
Briefly, Your Honor. Officer Foster, I apologize. We seem to get into some confusion. That night, when did you get a reading on your radar gun?
Again, I'm so sorry about that. It was about 12 a.m. that night when I about 1 a.m. when I got the reading on my radar gun. Defendant drove past me in that car that was in the accident later, got a reading of 54.
So if that was earlier in the night, when was the defendant traveling at 66 miles an hour?
That was a lot later when I wasn't able to see him. The reason we know that is because the way that the car was behaving on the road, the amount of damage that was done to the car, we're able to use what we know about physics and motion to back calculate how fast his speed was. We were able to calculate that his speed was 66 miles an hour when he approached the curb, much later than the radar reading.
Thank you. Your Honor, no further questions.
Henry Cross.
No, Your Honor.
Thank you, Officer Cross.
Thank you.
Mr. Ryan.
Your Honor, the state would like to call Dr. Avery Smith. May I proceed? Dr. Smith, would you please introduce yourself to the court?
Good morning, I'm Dr. Avery Smith.
Dr. Smith, what do you do?
Well, I'm the director of the Midlands Department of Forensics, and I'm also the chair of the board of drug and alcohol influence testing here in the state of Midlands.
And why are you here today?
I administered a breathalyzer test to Mr. Dawson when he was brought in suspected of driving under the influence.
What qualifies you to administer this test?
I have both a master's and a PhD from the University of Washington in biostatistics. I also have over 25 years of experience as a technician, instructor, calibrator, and operator of the Intoxilyzer 8000, which is the machine I used to take the reading that night.
What kind of data and equipment do you use to conduct this test?
It's really pretty simple. All you need is 2 breath samples from the subject himself, the machine, and several control samples to run through the machine to make sure it's working properly.
How do you run this test?
Essentially, you just have the subject breathe into the machine, it collects the sample, and it places it in a chamber where it shoots a beam of infrared light through it. Depending on how much of the light is either absorbed or reflected by the molecules in that sample, it can tell the chemical composition, and it can give you a reading for how much alcohol is in there. Once we know how much alcohol is in the breath sample, we use a simple ratio to convert that to how much alcohol is in 1 cubic centimeter of the subject's blood.
Is the Intoxilyzer 8000 and the procedure widely used by experts in your field?
It is. It's standard use across the United States.
Now let's recreate what happened that night. Why was the defendant brought in that night?
It's my understanding that he was brought in because Officer Foster, who brought him in, had administered some field sobriety tests after the defendant got into an accident and that resulted in the death of Vanessa Sullivan. The defendant failed all 3 field sobriety tests, so they brought him to me to test his blood.
When the defendant arrived, what did you start doing?
The first thing that I did was speak with the defendant and speak with the officer. I was finishing up calibrating the machine and making sure that it was working properly, which is why I was there so late to begin with. So I got a little bit of background information as to why the defendant was there, and then I administered the test.
What kind of background information did you get from the defendant?
First of all, I talked to the officer to see why he was brought in to begin with. Second of all, I had to make sure that he had been observed for at least 15 minutes before I administered the test. This is just to make sure that he didn't have access to anything like more alcohol or mouthwash that would cause there to be any residual alcohol in his mouth, because that could skew the test results.
Was he able to get access to any of these mouth alcohol or alcohol things?
No, Officer Foster had been observing him for more than 20 minutes, and he didn't have access to any of these things.
And before you did the test, what was your perception of the defendant?
When the defendant walked in, he was slurring his words, and he was stumbling. He seemed upset. He was pretty drunk.
When you did this test, do you make and keep any records of what you do?
Every time, we have 3 records. We have a checklist that outlines standard operating procedure that we go through and create every time we do one of these things. In addition to that, we have an operator's report where we enter data about the subject himself. And then we have the actual printout that comes out of the machine that contains the results.
Permission to approach the witness with prosecutions 4, 5, and 6. Your Honor, would you like a copy here? Dr. Smith, are these a true and correct copy of the documents you just were talking about?
Yes, this is the checklist. Here's the operator's report, and then these are the results.
And when were these documents made?
I created all these documents that night as I was administering the test.
Your Honor, I'd like to offer Exhibits 4, 5, and 6 as evidence in this trial.
Any
Objection
objection?
to the lack of foundation.
Okay, I'll take mine about Exhibit 4, which is
Exhibit 4, 5, and 6. Exhibit 4, 5, and 6 there's not been foundation laid as to if these are regularly kept in her course of business, or if creating these are a regular practice of her course of business. Therefore, I would object to the lack of foundation.
Your Honor, prior to bringing these exhibits up, I did ask if she made and kept records when she conducted these tests, and she answered in the affirmative. I think this foundation requirement has been met.
I do recall that testimony, so the foundation is been lacking.
I would just say that that was previously in the direct. It hasn't been established for these exact documents as they're for 4, 5, and 6.
I'll allow the exhibits. Do you have any objection?
No, Your Honor.
Good. May I publish these exhibits to the jury? Sure. Now let's go to your results for that night. What was the defendant's blood alcohol concentration that night?
We got a reading of 0.19, which is 2.5 times the legal limit here in Midlands.
And Dr. Smith, what does that really mean for how a person acts and behaves?
Well, 0.19 might seem like a pretty small quantity, but in reality, it's pretty drunk. We're working with a scale of 0.0, which is of course completely sober, to around 0.4 to 0.6, at which point, depending on the particular biology of somebody, they're either in the hospital or they're dead. So 0.2, 0.19, it's about in the middle of that range. That's your standard drunk person. They're impaired, they're uncoordinated, they're not making good judgment calls. They definitely shouldn't be operating a motor vehicle.
Thank you, Dr. Smith. Pass the witness.
Dr. Smith, you normally observe the subject for 15 minutes, correct?
That's right, it's very important.
Yes, and you do this because to ensure that there's no residual amount of alcohol on the subject.
Exactly, like I explained earlier, that can contaminate the results.
Yes, and burping or acid reflux could cause residual amount of alcohol.
Of course it can. Any alcohol welling up from the stomach, especially after a subject has been drinking a lot, that can definitely throw off the results.
Well, a burp or acid reflux could lead to higher BRAC results.
Exactly.
Now, you asked Officer Foster if the defendant had been observed for 15 minutes, correct?
Of course I did.
And Officer Foster told you that he had actually been observed for 20 minutes.
Yeah, you did.
Yet, this 20 minutes was the whole ride to the station, correct?
That's right, and the time that Officer Foster spent conducting field sobriety tests with the subject beforehand.
But as Officer Foster was driving the defendant to the station, he was focused on driving, wasn't he?
Well, I'm sure he was.
He wasn't watching the defendant the whole entire time.
He told me that he was.
Objection, Your Honor. Speculation.
May I respond? I'm just asking her a simple question. She can answer yes or no to her rationally based perceptions.
He told me that he was. All of our officers are trained by me personally to observe subjects that they suspect of having been drinking and driving. Officer Foster knows how to observe a subject to make sure that there's no residual amount of alcohol before I conduct a test. He told me that the subject had been observed.
On the ride to the station.
That's right.
Yet the defendant could have burped or had acid reflux during that time.
The defendant didn't say anything to me about having had that or having done so, and neither did Officer Foster, so I don't believe the defendant did.
Dr. Smith, you actually never asked the defendant if he had burped or had acid reflux.
That's right. If you ask a subject whether they've burped before you administer the test, oftentimes the subject will start burping because that makes it impossible for us to conduct the test. It's a common way for somebody to get out of having to give a breath sample.
And the defendant, Mr. Danny Dawson, could have burped on the ride home, correct?
Well, like I said, Officer Foster didn't report it and neither did he. I suppose he could have. I wasn't there. I don't know.
So are you saying no, he couldn't have burped, or yes, he could have burped?
I'm saying there's simply no way for me to know for sure, but the information that I do have tells me that he didn't.
That's exactly. You have no way to know for sure because you did not ask, correct?
Well, I wasn't there.
Now, moving on. This actually, if Mr. Dawson did burp, this could skew the results, correct?
Sure it could.
Leading to higher than normal BRAC results.
Yes, it could.
Now, the defendant, Mr. Dawson, was cooperative throughout the whole test, correct?
He was cooperative, he was unhappy, but he did what I instructed him to do.
And before you actually began the test, you thought his BRAC results would have been a lot lower, correct?
That's true.
Dr. Smith, you were surprised that his blood alcohol concentration was as high as it was.
That's true. He had a surprisingly high tolerance.
No further questions.
No, Your Honor.
Thank you.